Police resources at breaking point on a bloody Sunday in the city. Despite a blockade of police, rival protesters came head to head.
Is March for Australia a constitutional win or failure? We are seeing Australia experiencing an unprecedented wave of high-frequency social movements. Within only 4 weeks after I made my first video revealing the legal issues regarding the Bridge March on 3rd August 2025, another nationwide march took place on the last day of August. 2 marches, but 2 very different legal stories. One protest to secure a court's blessing, while the other sparked controversy over police powers and public safety. What are the legal issues in common? What make them different? I will break down all legal issues in this video, and by the end of it, I will answer these 3 questions. Firstly, whether March for Australia is constitutionally protected. Second, whether police are biased by not applying for any prohibition orders as opposed to what they did against the Gaza assembly on Harbour Bridge on 3rd August. Thirdly, what are the things you can do to protect your rights irrespective of whether you are for or against such assembly. In the video, I will also correct one misconception, which is commonly used by public media. Now let's get started. On 31st August 2025, March for Australia took place in most capital cities, including Sydney, Melbourne and Brisbane, causing lots of public debate. In Sydney alone, there were 4 public events on the same day, including a counter-protest by the Refugee Action Coalition. Based on the publication of Australian Bureau of Statistics, the number of net overseas migrants has quite steady and averaged at around 200,000 per year. But such numbers surged and doubled after pandemic. Supporters of the assembly argue that rapid high levels of immigration have strained housing, infrastructure and community cohesion, while critics argue that the movement of March for Australia is driven by far-right extremists and will lead to social division. Leaving those political debates aside, the first question is whether March for Australia is legally protected or prohibited. The short answer is that it is protected due to freedom of assembly, but with certain limits. The important concept here is, what is freedom of assembly? What are the laws protecting it? And what's the scope of such freedom? Now, let's review the first question, whether March for Australia is constitutionally protected. The term freedom of assembly is commonly used interchangeably with freedom of association, both referring to the rights for people to express their political opinions, engage in social activities, form and join trade unions and cooperatives, and elect leaders to represent their interests. Why protecting right of assembly is important, and what is the legal framework of such protection? Let's look at it from the following perspective. Firstly, what are the international law requirements? Secondly, what are the common law precedents? Thirdly, what does constitutional law say? And lastly, what are the legislations at the state or territory level? Firstly, international law. The right to peaceful assembly is recognized by international law. Article 21 of the International Covenant of Civil and Political Rights states, the right of peaceful assembly should be recognized. No restrictions may be placed on the exercise of this right other than those imposed in conformity with the law and which are necessary in a democratic society in the interest of national security or public safety, public order, the protection of public health, or morals or the protection of the rights and freedoms of others. However, Australia is not bound by international laws unless the federal or state government legislature decides to incorporate those provisions into Australian law. The Commonwealth government hasn't done so. Therefore, the International Covenant of the Civil and Political Rights has no domestic application and affords no protection to protests in Australia. Let's look at the common law. It is the common law right to assembly that provides the legal basis of what is commonly called the right to protest. The origins of the common law right to assembly could be tracked back 800 years ago to the signing of Magna Carta, followed by various English statutes dealing with meetings and gatherings for political campaigns. The common law right to assembly has been expressly recognized by Australian courts. Such right is considered as precious democratic rights and common law freedoms, as stated by Justice Adams in New South Wales Commissioner of Police and Banbridge 2007 NSWSC 1015. Peaceful assemblies are perfectly reasonable and entirely acceptable modes of behavior in a democracy. As long as there are no conflicting statutes, the court will always adhere to the common law principles that protect the right of assembly. And even if there are potential conflicts, the courts, where possible, will always interpret the statute in a manner that minimizes the impact on the common law rights. Next, we have implied constitutional right. Contrary to many people's belief, the Australian Constitution does not explicitly provide a right to assembly. This is contrast to US Constitution, as Australia doesn't have a Bill of Rights. But it is broadly accepted that the rights of assembly are implied by the Australian Constitution, in particular under the implied freedom of political communication. There are a long list of cases supporting this implied right, but we will not elaborate them for the purpose of this video. One thing to keep in mind is that the implied freedom of political communication is not limited to verbal communication. It extends to protests and other forms of non-verbal collective communication. Now let's look at the state legislation. The scope of the implied freedom of communication is not limited to the federal level. It applies to a law of a state or territory parliament. In New South Wales, it has a statutory scheme relating to public assemblies in Part 4 of the Summary Offences Act 1988. In Queensland, the relevant legislation is Peaceful Assembly Act 1992. In Victoria, it is Charter of Human Rights and Responsibilities Act 2006. And in ACT, it is Human Rights Act 2004. Take New South Wales as an example. Part 4 of the Summary Offences Act 1988 facilitates the exercise of the common law right to assembly. It is an interesting piece of legislation. Instead of explicitly granting or taking away rights, the goal of Part 4 is to encourage cooperation between protesters and police. And if an agreement cannot be reached, protesters can still choose to proceed with their protest, and the police can still enforce the law in the usual manner. What does that mean? Let's look at the key provisions of Summary Offences Act. These are Section 23, 24, and 25. Under Section 23 of the Summary Offences Act, the protest organizers may provide a notice informing the Commissioner of Police of their intention to protest and the related details, including the proposed location, route of protest, how many people will attend, and the duration. Section 24 provides that people who participate in an authorized public assembly and act substantially in accordance with the details furnished under Section 23 notice are not guilty of participating in unlawful assembly. Section 25 provides that the Commissioner of Police may apply to a court for an order prohibiting the holding of the public assembly. The Commissioner of Police can only do so if he has first served on the organizer of the public assembly a notice inviting the organizer to have a chat about the assembly and then take into consideration any matters raised by the organizer. This reflects the legislative emphasis on negotiation and cooperation. The factors the police is to consider include the time of assembly, the expected duration of the assembly, the location of the assembly or intended route of the assembly, the purpose of the assembly, the number of people and vehicles involved, the likely pedestrian traffic present, whether other special events will be occurring on the same day, the likely disruption caused to public transport and other persons, and any other notified special characteristics of the proposed assembly. Stop here for now, and I will clarify an interesting fact of New South Wales legislation. Neither Section 23 or Section 25 of the Summary Offences Act say that you cannot protest without notice to the police. What it says is that if you give prior notice, then the assembly is deemed to be authorized, and that opens the door for extra protection under 24. As Justice Adams succinctly pointed out in the New South Wales Commissioner of Police and Banbridge, an order made under Section 25 prohibits really nothing. Despite prohibition orders issued, people may still attend the event and no arrest could be made if it is entirely peaceful. If you want to see how these provisions interact and argued in the Supreme Court of New South Wales that eventually impact on the Bridge March for Gaza on 3rd August, You can check my earlier video below. The difference between the Bridge March on 3rd August and March for Australia on 31st August is that the police applied for prohibition orders against the Gaza Assembly under Section 25, although the application was unsuccessful. However, the police did not apply for prohibition orders under Section 25 for the March for Australia, which makes people raise a legitimate question as to whether this represents the police's political stance in favor of certain groups, whether the police is biased and discriminatory against other groups of people, and whether people can stop or challenge such protests. Whether police is biased or not, by not applying for any prohibition orders as opposed to what they did against the Gaza Assembly on Harbour Bridge on 3rd August depends on how you interpret the legislation. By looking at the wording of Section 25 of the Summary Offences Act, firstly, we can say only police can make an application for prohibition orders, not anybody else. Secondly, the wording of Section 25 gives rise to the police discretionary power. It only requires the police to hold conference and discussions with the organizer and take certain factors into account. After that, the police may or may not apply for prohibition orders. Therefore, without knowing what has been truly discussed between the organizer and the police, and what terms the parties have agreed to, it is hard to say whether the police is biased or not. Theoretically, one may challenge against the police for failing to apply for prohibition orders against certain assembly groups, but it is not enough for you to just say that if you were the commissioner of police, you would have done something differently. You need to first establish your standing by showing that you are directly affected. For example, you are the organizer of a protest whose assembly was treated differently due to the police decision. Secondly, you need to show there is some kind of illegality, unreasonableness, existence of bias or lack of procedural fairness. For example, you need to prove that the police decisions were influenced by irrelevant factors such as political pressure and prejudice against certain groups. This is always hard to prove if you are not one of them. Thirdly, since it is a discretionary power, you also need to establish that it is so unreasonable that a reasonable commissioner of police would have applied for prohibition orders given all the circumstances, which queries on someone's decision-making process and actual knowledge. Lastly, even if you challenge the police decision successfully, the assembly had already occurred, plus you are unlikely to get any compensation because there is no actual loss. And by the way, such kind of proceedings are complex and costly. That explains why so many people complain about assembly, but no real court actions have been taken to stop it. Yes, you may lodge a complaint to the Police Integrity Commission if you believe the police acted in a biased or discriminative way, but it probably wouldn't make things different because the event has already happened. Before we touch on the last topic on what are the things one can do and cannot do in exercising their rights during assembly, I would like to correct one misconception widely spread in media. The media often speak of violent protesters and violent protests. These wordings are often used to attract people's attention on social media, increase reviews, stir debates, but unnecessarily divide people and cause fears, hatred, and retaliation. The truth is, the right to protest does not extend to violence. Most of those assemblies were communicated with police beforehand and were conducted or at least labeled as in peaceful way. Final topic, what are the things you can do to protect your rights irrespective of whether you are for or against such assembly? These are the laws that you can protect yourself if you are migrants, and if you are the participants of the assembly, these are the boundaries that you do not wish to cross. Firstly, breach of peace. This is an old common law principle. A breach of peace has been found to occur whenever harm is actually done or is likely to be done to a person or to their property. It may apply when a person is in fear of being harmed through an assault, unlawful assembly, or other disturbance. So when you see the police use this power to give directions, for example, shouting, "Move on" or "Stay away," follow those orders and do not get yourself into trouble. Second, obstruction. Section 6 of the Summary Offences Act provides that it is an offence for a person without reasonable excuse to willfully prevent in any manner the free passage of a person, vehicle, or vessel in a public place. This means that you cannot just go to somebody's front door to protest and then block their driveway. Obstruction is also prohibited by the Road Rules 2014. Then we have offensive conduct and offensive language. Section 4 of the Summary Offences Act states that a person must not conduct himself or herself in any offensive manner in or near a public place or school. So one cannot go to the bus or school to curse your children's teacher or other children's parents. And the test is whether a reasonable person in that position will be offended. Then we have unlawful assembly. Section 545 capital C subparagraph 1 of the Crimes Act provides that it is an offense to knowingly join or continue to be part of an unlawful assembly. An unlawful assembly is defined by Section 545 capital C subparagraph 3 to be any assembly of 5 or more persons whose common objective is by means of intimidation or injury to compel any person to do what that person is not legally bound to do, or to abstain from doing what the person is legally entitled to do. For example, you cannot force somebody to sing Advance Australia Fair, no matter how you love the song. Next, we have affray. Section 93 capital C subparagraph 1 of the Crimes Act provides for the offense of affray, which is committed when a person uses or threatens any unlawful violence towards another and causes that person of reasonable firmness to fear for his or her safety. There is a maximum penalty of 10 years imprisonment. Another similar offense is violent disorder. Section 11 capital A paragraph 1 of the Summary Offences Act provides that if 3 or more persons who are present together use or threaten unlawful violence, and their conduct taken together is such as would cause a person of reasonable firmness to fear for his or her personal safety, each of the person using or threatening unlawful violence is guilty of an offense. Then we have assault during public disorder. Section 59 capital A of the Crime Act provides that a person who assaults any person during a large-scale public disorder, although not occasionally actually bodily harm, is liable to imprisonment for 5 years. Where you occasion actual bodily harm, then the penalty may go up to imprisonment of 7 years. Assault and other actions against the police officer. When protest turns violent, the violence is often directed at police, such as throwing stones and bottles. So Section 60 of the Crimes Act is designed to give police that protection. Depending on whether the police is suffered from actual bodily harm and the degree of injury, the maximum penalty can be between 7 to 14 years imprisonment. Then we have right. Section 93 capital B subparagraph 1 of the Crimes Act provides that where 12 or more people together use or threaten unlawful violence for a common purpose and their conduct taken together causes a person of reasonable firmness to fear for his or her personal safety, each of the person using lawful violence for the common purpose is guilty of right and liable to imprisonment for maximum 15 years. So that mainly applies to a large group of people. That's why peaceful assembly always has a design route, which is easy to manage. When it gets spread out, things can go beyond control. Then we have unlawful entry. Enclosed Lands Protection Act 1901 provides that if protesters entering and remaining on public or private lands that are surrounded by a fence or wall, they are committed an offense. Enclosed lands also include lands surrounded by cliff or river, as long as it separates itself from others and has clear boundary. So if you are living in a house without a fence, it might be a good idea for you to think of having it. Destroy or damaging property. Protesters who intentionally or recklessly destroy or damage public or private property are, under Section 195 of the Crimes Act, liable to imprisonment for up to 5 years. Higher penalties apply if such damage is caused by a group of people or during a public disorder. There are also other crimes relating to interference with mining and forestry activities which we will not further explore for the purpose of this video. Lastly, the persons harmed by assembly can also pursue a compensation against the protesters under civil law, including torts of trespass, nuisance, interference with contractual relation, injury to trade or business. We will not focus on those concepts here due to time constraints, and in practice, they are difficult to pursue. You probably wouldn't say to a group of people who passed by and damaged your property during a rally that, "Hey gentlemen, may I take down your names and address, please?" Thanks, Mr. Jon Snow. You were the person broke my window, which cost $300 to repair, and my lawyer will send you a claim for that amount later on, so you may keep moving and have a nice day. And a small tip is, if your property is damaged, it may be wiser to consider making claims for victims' compensation under the Victims' Rights and Support Act 2013 because they are usually much cheaper to obtain rather than a judgment in a civil litigation. Before we conclude this video, an interesting fact is that the right to protest peacefully originated from the desired tolerance of dissenting minority opinion. In this sense, you don't see majority people protesting. Rather, we see silenced majority because they have already reached consensus and are able to affect the lawmaking. So if you belong to the majority, you've already won, and try to be more tolerant towards the minority who would like to have their voice heard. Protest is an integral part of a democratic process, although it may present risks to social order. No matter how peaceful it can be, a protest is essentially an expression of opposition and a physical manifestation of social discord. Therefore, they are inherently polarizing. Australian laws protect freedom of assembly, but that does not extend to unlawful assembly and violence. No right is absolute. The right to peaceful assembly finds limit under civil and criminal law. As long as you are not breaching the law, you are good to go. If you or your property is harmed by people in the assembly, now you know how to protect your interest. Keep your evidence, call your lawyer, or report to the police. Last but not least, if you are not happy with others, no one prevents you from making the protest in a similar fashion, announcing your appearance, letting your voice be heard, and helping pass on torch to the next generation. Thanks for watching. We'll see you next time.